This is Barry Zalma speaking on the law of torts for the insurance claims professional. I have been involved in insurance claims, insurance coverage. I've spoken as an insurance claims handling and insurance fraud consultant and expert witness, and I have been in the insurance business for more than 50 years. Representing as an attorney and as a claims person, national and international insurers from A to Z. I practiced law as an insurance lawyer from 1974 until 2015, when I allowed my license to become inactive, so that I no longer practice law but only act as an instructor, a speaker on insurance matters, an insurance consultant, and an insurance expert witness. This tort law program is a part of my Excellence in Claims Handling program, which will be available on the internet. Today we're going to talk about the law of torts and why every first-party property claims professional, as well as the liability claims professional, needs to know about the law of torts. You should get from this course an understanding of the law of torts, enough to deal with tort law and claims of torts, not enough to be a lawyer, because even the law school course for torts is a one-year course. It is not as difficult as they made out in law school, and it is not a difficult concept that you cannot understand and that you will understand after you complete this course. You will understand why insurance claims personnel require a knowledge of the law of torts to properly investigate an insurance claim, because whether it's a first-party property claim or a third-party liability claim, the law of torts is important to the investigation. So what is a tort? To put it simply, a tort is not a pastry. It is a civil wrong. It is where someone has done something to either harm the person or property of another, and they have done so either negligently or intentionally. If a tort can be proved, the injured party is entitled to recover damages from the tortfeasor, that is, the person responsible for the injury. The basic elements of a tort, if you wish to prove it in a court of law, it is necessary that the investigation of an insurance claim determines the following elements. First, that there is a duty. Now, everyone in the United States has a duty to act in such a way as to not cause harm to a third person or the property of a third person. This is the general duty. There are specific duties that might be taken on because of a contract or because of a specialty in your profession. Once you determine that there is a duty, then you must determine what that duty is and whether or not someone has breached the duty. That means they failed to act in such a way that they have caused damage to another person, either by accident, by their lack of concern, or by their lack of attention. That breach of duty, standing alone, means nothing, because if you breach the duty, then to prove a tort, you must prove that there was damage done either to the person or property of another as a direct result of the breach of that duty. The direct result is what lawyers will call the proximate or legal cause of the breach. Every person must realize that they live with the basic duty that is imposed on all people, and that is to avoid acts or omissions, that is, a failure to act, which can be reasonably foreseen to be likely to cause a harm to another. So, for instance, driving 130 miles an hour in a school zone might make it impossible to stop if a child walks across the street, and that would be an omission to act reasonably, and it would be something that you could reasonably foresee might cause injury to or harm to a third person. If a person fails to act toward others and the public with watchfulness, attention, caution, and prudence, that a reasonable person in the circumstances would so act, then you may have breached the duty. And the breach could be something as simple as reciting a fact situation that is a lie that causes injury to a third person, or throwing a banana peel in front of a person walking next to you so that he will slip and fall, or failing to clean up a mess that you know someone might trip into. There are multiple ways to breach this common duty, and we all should recognize what those ways are and try to avoid them. If a person's actions don't meet this standard of care, then the acts are considered negligent because there was a duty imposed on the person. He breached that duty by not meeting the standard of care, and those acts caused a damage which are a result of negligence. And an insured who does this, a person who is insured, will be sued for his or her negligence, and it is up to the insurance claims professional to complete a thorough investigation to determine whether or not the actions acted as an act of negligence that could cause damage to a third person or did cause damage to a third person. The duty of care is defined by courts as a legal obligation which is imposed on an individual requiring adherence to a standard of reasonable care while performing any acts that could foreseeably harm others. And these acts might be the operation of an automobile, a motorcycle, a scooter on the streets, a bicycle on the sidewalk that might cause harm to a third person. All of these are subject to this legal obligation. And if the person fails to fulfill that legal obligation and causes injury to a third person, he or she can be held responsible for the breach of duty and any damages that result from them. The duty of care can be considered a formalization of a social contract, the contract that we all enter into without even putting it down in writing, just because we live in a civilized country, a place where people have to work together. And it is implicit that individuals in the society must take the responsibility to do no harm to third persons. Now, when the duty of care is breached and a person or property is damaged, then a tort has occurred. And because a tort is a wrong committed by one person against the person or property of another, the injured party, under our system of law, is entitled to sue to recover indemnity for the damage. And this might be simply enough to pay for the replacement of a pair of shoes that were damaged by negligence, to millions of dollars to indemnify an injured person for serious personal injuries done to his or her body as a result of the negligence of the person insured. And it is up to the insurance claims professional to determine what caused it, what the liability of the insured was, and the extent of the injury. Now, not all torts are subject to absolute liability. In fact, very few are. The law allows certain defenses to claims of negligence or other torts. One of those defenses was the defense of contributory negligence. And when I was a young adjuster, some 52 years ago, the defense of contributory negligence applied so that if the person injured in any way, in any small proportion of the breaches of duty, contributed to his or her injury, there would be no recovery allowed in tort. Now, that was a fairly egregious system that made it impossible for people who were severely injured by the torts of another to recover for indemnity from the tortfeasor. A person who was only 1% responsible for an accident could recover nothing from the person 99% responsible. And as I grew older and worked my way through being a claims representative and a lawyer, modern courts found the result of this contributory negligence defense to be inappropriate and unfair. In my home state of California, one of the first courts, if not the first court, to do away with the defense of contributory negligence did so in a case called Lee versus Yellow Cab. And in that case, they determined that Ms. Lee was entitled to recover damages that were comparative, so that the amount of Ms. Lee's negligence was used to limit the amount of total recovery by subtracting a percentage of her negligence. And Ms. Lee's first name was Ga, and perhaps the court chose the case for that reason, since every lawyer who ever dealt with contributory negligence as a defense and now found that they had to use comparative negligence would always say, golly, that was a heck of a decision. When the law of negligence was young, there was an absolute defense, and now it's not. Most accidents that cause damage to property are the result of the partially negligent acts of more than one person. And so the doctrine of comparative negligence, which was first set forth in the Lee versus Yellow Cab case, where the plaintiff's recovery is reduced by the percentage of his or her negligence. And this, anyone can argue, is a fair result. So that if, for instance, Miss Lee was 50% responsible for her injuries, and the tortfeasor was 50% responsible, the jury would find perhaps that the plaintiff's injuries were valued at $100,000, and on a 50% liability situation, the plaintiff would recover $50,000 of the $100,000 in damages, so that her own responsibility would be applied to the final result. Now, some torts, on the other hand, are not negligent. Some torts are intentional. One of those intentional torts is the tort of libel. Libel is a tort that is committed in writing. It can be in a book, a newspaper, a letter, an email, a fax. Any written communication can be the subject of a libel, where a written wrong against the reputation of a third person exists. Slander, on the other hand, is similar to libel, but is oral, not in writing, but it is still a wrong against the reputation of another person, spoken to others but not written. And these wrongs can be as simple as a statement that the plaintiff was a criminal, or a prostitute, or a liar, when in fact he or she was not. These evil statements make up the intentional torts of libel and slander. On the other hand, a negligent tort could be careless driving, where an impact results causing damage to another person's property or a person's health. When one drives an automobile in such a situation, so fast and so negligently that it ends up on the roof of a person's house or in their bedroom, one can rationally assume that the operation of the vehicle was negligent, and the damages caused by that vehicle will be part of the tort of careless driving, which is a variation on negligence. Defective manufacture of a product is a tort, so that if a construction company negligently constructs a bridge and it simply falls apart, there is a good possibility that the bridge was not manufactured carefully, that it was either manufactured negligently or intentionally as a bad and not secure structure. And if anyone was injured when that bridge fell or drove over it into a hole, there would be a finding of liability on the part of the manufacturer of the property. And any damages to a person's property or person would be recoverable as a tort damage. To prove the tort, the three elements must be established, and this is the responsibility of the claims person, who must thoroughly investigate the facts surrounding a claim of tortious conduct to determine that the person committing the tort had breached a duty, whether it's the basic duty established by the common law that every person will use his or her property or person in such a way as to not cause injury to another by lack of ordinary care, or by some intentional acts. The evidence necessary is evidence that can be admitted in a court of law. And this evidence can be as simple as the sworn statement of a person, physical evidence, like a broken automobile or a damaged house, or other admissible evidence, including expert testimony of an expert who knows about reconstructing automobile accidents. To prove the cause in fact portion of the elements of the tort, one must and usually will apply the but-for causation test. That is, you must ask and determine that but for some conduct by the defendant, the insured, the accident would not have occurred. So, but for the driver of the blue car in the picture going 70 miles an hour into the red car who was stopped at a stop sign, there would not have been an accident. So, but for the defendant's actions, the plaintiff's injuries, either to his vehicle or to his person, would not have occurred. Now, lawyers call this but-for test a determination of proximate cause. A defendant in a negligence case is only responsible for those harms that the defendant could have foreseen through his or her actions that were specifically caused by his or her actions. So that if the accident and injuries to the Audi in the picture above was due to the fact that another person, not the driver of the Audi, backed into it, then the proximate cause of his injury would be the vehicle that backed into the Audi. Well, if the Audi drove into the back of a parked vehicle or a person or a piece of property, then the proximate cause of the injury would be the operation of the Audi in a negligent fashion. If a defendant has caused damages that are outside of the scope of the risk that the defendant could have foreseen, then the plaintiff cannot prove that the defendant's actions were the proximate cause of the plaintiff's injury. For example, if the operator of this vehicle had a stroke while operating it without any warning, he did not act in such a way as to cause the injury. He was not negligent. Something got him out of the ability to control his vehicle, something he had no control over, whether it was a stroke or a heart attack. If he had no control, if he or she did not act in such a way as to breach the duty, then there is no responsibility. Now, of course, the third element is damages. And this gentleman is clearly damaged with a black eye and a broken arm and crutches. And in a negligence case, you must prove that there was a legally recognized harm, usually in the form of physical injury to a person or property that can be established by collection of medical records from his doctors or a hospital or an ambulance driver, and that those injuries resulted from the failure to exercise reasonable care. And there are truly actual damages. And there's no question this poor guy was hurt. And he has suffered actual damages. And then the question is, why? And once the three elements are established, the breach of duty, the cause, the proximate cause, and the damage, then you have established a tort, and you need to deal with that tort by determining the extent of damages that your insured defendant is responsible for. Now, in a libel or slander case, the person perpetrated a false statement must understand whether he's a newspaper or just a normal individual, that the newspaper owes a duty to persons about whom it prints stories to print the truth. If a newspaper prints a story about a person it knows is not true and causes him damage, it has breached that duty, and the breach of the duty that causes damage can result in a recoverable tort. A driver of an automobile owes a duty to all others on the road to operate the automobile in such a way as to not harm others. If, for instance, the operator of the automobile runs a red light and strikes a person, he or she has breached the duty. If the operator of the automobile decides to take a shortcut by driving up on the sidewalk and run someone down, he has breached the duty. Now, to prove the tort, all three elements have to be established using the but-for test. And if you, as a claims person or as an investigator, can establish that but for the actions of the defendant, plaintiff would not have been injured, then you're going to need to start thinking about resolving the claim of the plaintiff. If, on the other hand, the evidence you collect establishes that but for the actions of the plaintiff, he would not have been injured, then you must be ready to prove a defense that it wasn't the defendant's obligation and he breached no duty. If a story in a newspaper is read by plaintiff's boss, who fires the plaintiff based on false statements in the newspaper, that's a breach of duty. But for the actions of the newspaper in publishing a false story, the plaintiff would not have been fired, and he would not be able to suffer the damages the lack of a job and the lack of an ability to get another job is deprived from him. If an auto collision results in the plaintiff's loss of earnings, those are real damages that the plaintiff will seek to recover from the tortfeasor. If the plaintiff's broken leg must be set as a result of the negligence, failure to carefully operate an automobile, and he incurs medical costs, those are damages that can be recovered. In addition, courts will allow the plaintiff to recover additional damages for pain and suffering or trouble and inconvenience. These are damages that are not necessarily obvious. General damages that are subjective, while the damages for the setting of the broken leg are practical, easily proven, actual damages that are usually denoted in the claims business as special damages. And when you take the special damages and the general damages, you add them together, you have the amount of indemnity that the plaintiff is entitled to receive, and that a court or jury will give to them if it is necessary to bring the case all the way to trial. whether the tort is accidental, negligent, or is intentional. In either event, the person to whom the wrong is done is able to sue for the damages he or she suffers as a result of that wrong. That is our system. Insurance claims people understand this, and insurance claims people work to resolve the problem, to save the insured both the costs and trouble of going to trial, and work to resolve a tort claim at the claim stage, hopefully even before the involvement of lawyers on either side. And if lawyers are involved, the claims person works with the lawyer for the plaintiff to resolve the claim. Now, the injured party, if he has to go to trial, must prove that the wrongdoer, your insured who is seeking a defense, had a duty not to harm the property or person of the plaintiff, and that he or she breached that duty by driving recklessly, by telling lies, by doing something that he or she knew should not be done that causes proximately a breach of the duty that damages the property of the plaintiff or his body. Now, other intentional torts include assault or battery. An assault is defined as an intentional, unlawful offer of corporal injury to another by force. In other words, you threaten to punch a guy in the nose, and you're close enough that you have the potential to actually punch him in the nose and cause him fear that he will be punched in the nose. Force unlawfully directed towards a person of another, under such circumstances as will create a well-founded fear of imminent peril, coupled with apparent present ability to execute attempt if not prevented, will be an assault. Because, in fact, he didn't punch you in the nose, but he scared the heck out of you because you expected him to punch you in the nose. He was standing within 2 feet of you and had every opportunity to do so, and that would be the intentional tort of assault. Battery, on the other hand, is where the assault threatened is actually carried out. So if a defendant starts a fight and hits his neighbor intentionally in the jaw, the defendant has deliberately committed a tort against the neighbor. That tort is called battery and differs from assault only in that the present ability is carried out. And you are hit in the face, and you are damaged. Your jaw is broken, your nose is broken, you're bruised. In any event, it is an unwarranted touching that causes an injury to another. And this touching could be very slight, and it can be very severe. Regardless of the severity of the unwarranted touching, in both cases, it is a battery. So that if a politician on a campaign trail decides to hug your wife, who doesn't want to be hugged, that can be a battery because it's an unwarranted touching. And it is just as much an unwarranted touching as the neighbor who punches your wife in the jaw. Both are intentional torts. Both are batteries. The only difference is the extent of injuries. Some torts are committed to do harm to another that are so egregious, so vile, that they are always intentional, that there is no potential for a finding of negligence. And these include the assault or battery of a sexual nature, or the unqualified and unlawful touching of a minor, whether sexual or not, that causes harm to the minor. There is never a question that an unwarranted and unlawful touching of a minor is a battery, is an intentional tort, and something that will seldom be covered by a third-party liability insurance policy. Another intentional tort is the tort of trespass. A person who comes on the land without privilege or consent commits the tort of trespass. A person who trespasses is presumed to have harmed the land. Simply walking on someone else's grass where no visible damage is done is presumed to have harmed the land. It is the extent of the harm that is subject to proof and that may result in a de minimis type award of damages, perhaps $1 or 30 cents or a penny. But if you actually do real damage, like cut down a tree or steal some fruit, the extent of damage could be greater. Defamation, libel, or slander is another intentional tort. It can't be done accidentally. The Second Restatement of Torts sets forth the legal elements required to prove defamation. They include false and defamatory statement concerning another, an unprivileged publication to a third party. A newspaper publishes it to many third parties by sending it out. An individual might publish it to a next-door neighbor. In either way, they are an unprivileged publication to a third party and need to be punished. The Second Restatement also includes that the following additional conditions to prove defamation. There must be fault, at least to negligence on the part of the publisher, and either actionability of the statement, irrespective of special harm, or the existence of special harm caused by the publication. A woman falsely accused of being a prostitute might lose a good marriage, might never be able to speak to her children again. A man accused of embezzlement falsely will never work again. His damages could be excessive. A false statement of fact is actionable if it's defamatory. On the other hand, a pure opinion, I think you're ugly, is not. A pure opinion, I don't like the way that suit hangs on you, is not actionable. Statements of pure opinion are not actionable as defamation because they're considered protected speech. We do have a First Amendment in the United States, and it allows us to say just about anything we want as long as the statement is not intended to harm a third person. For instance, a statement that I am a lawyer is not actionable. A statement that you are a lawyer, whether you are or not, is not actionable. A statement that you are a crooked lawyer, a criminal, that is actionable. The law distinguishes, therefore, between pure expressions of opinion, which are protected, and false factual statements, which are not. Generally, pure opinion is reasonably understood to be nothing more than the speaker's subjective viewpoint. So if I am in an art gallery and see a painting by a modern artist who is standing next to me and I say, "That's an ugly picture," he might be insulted, but he has not been defamed. If, on the other hand, I say, "Well, that painting wasn't painted by the person who signed it. It was painted by Joe Smith, who I know, and he is falsely selling as his own Joe Smith's painting." If that statement is false, and knowingly false, then I have defamed the artist. To prove defamation, it is up to the plaintiff to establish, with admissible evidence, that there was a publication, information communicated to some third person who understands its defamatory meaning and application to the plaintiff. If a false statement is made to the defamed person alone, it's not published. So when I say to the artist he didn't paint that picture and he's falsely selling Joe Smith's work, I have not defamed him. But if there's somebody standing next to the artist when I say it, I have. And this is the kind of evidence that needs to be gathered by statements, recorded statements, interviews, recordings, and what other physical evidence can be collected. To prove defamation, the plaintiff has to establish that the publication was false, that in fact he did paint the work of art. The publication was made with an intent to say what was said, and that the publication damaged the plaintiff. Because if the person was about to buy that painting that was standing next to the artist when I made the false statement and then did not buy the painting, the artist was damaged. Actual malice needs to be proved. The meaning of terms such as actual malice and more particularly reckless disregard is not readily captured in one infallible definition. Really, to prove actual malice, you need to get into the mind of the person making the false and defamatory statement. And if that person is Snidely Whiplash, who you know and who many people know well to be a liar and to be evil, and who knew the truth and knew that the statements he was making were not true, then you've proved actual malice. And it must be proved while knowledge of falsity is a clear standard. Reckless disregard is a standard that requires the plaintiff to bring forth evidence that the defendant entertained serious doubts as to the truth of the publication at the time it was published. So if the newspaper heard a rumor and published it as truth without doing any background checking, without doing any fact checking, then it might have been, and you may be able to prove it acted with reckless disregard, although perhaps not actual malice. Another intentional tort is the tort of false imprisonment. It is the unlawful violation of the personal liberty of another. And he doesn't have to be put into a jail or arrested. One can falsely imprison another by just keeping him from moving. So that if a storekeeper thinks an individual was shoplifting and locks him in a small room waiting for the arrival of the police, without knowledge, without proof, without evidence, that restriction into the small room or the refusal to allow him to leave the store can be a false imprisonment. The tort only requires direct restraint of the person for an appreciable length of time, and the plaintiff must have been compelled to stay or go somewhere against his or her will. Physical force can be slight, like an officer putting his hand on a person's shoulder, or a storekeeper just standing in the doorway. Actual force is not essential. The restraint can be by words, gestures, acts. A false arrest is one way to commit the tort of false imprisonment. If you arrest him, put handcuffs on him, and hand him over to the police, that's another kind of false imprisonment. Another tort is the tort of malicious prosecution, a clearly intentional tort. Another obvious intentional tort is the tort of malicious prosecution. Originally, this tort was limited to unjustifiable criminal litigation. That is, you falsely accused your neighbor of burglarizing your home, or of setting fire to your home, or of setting fire to his own home to defraud an insurer, when you had no facts or knowledge to support it, and he was arrested and taken to trial. It causes damage to the reputation of the person, and it causes him the damages of defending the false criminal prosecutions. These are egregious, evil types of intentional tort. Now, initiating or procuring the arrest and prosecution of another under lawful process but for malicious motives and without probable cause is the tort of malicious prosecution. But also, filing a lawsuit without probable cause, a civil suit, can be proved to be a malicious prosecution. And that, for public policy purposes, is not a favored lawsuit. So the tort now applies to maliciously prosecuted civil actions as well as criminal actions. So if I sue my next door neighbor for unlawfully causing bodily injuries to me when he's never even come close to me, I have committed the tort of malicious prosecution. Or if I sue a lawyer for malpractice because he only won a case he brought for me, and I had no reason to believe that he did so improperly, that can be a malicious prosecution, and once the case is successfully defended and proved to be of no merit, then that lawyer or that neighbor can sue me for malicious prosecution. To prove the tort, the following elements must be established: that the defendant, the person you maliciously prosecuted was acquitted at trial, or the case was dismissed without trial, or there was a defense verdict in a civil case, or the judge threw the case out because there was no evidence to support it. These are the kinds of things that must first be proved before a plaintiff can establish a malicious prosecution. Some torts, unlike malicious prosecution, can be automatic. If one can establish that a plaintiff was injured as a result of the violation by the defendant of a statute or some municipal ordinance, there is a presumption of negligence, sometimes called negligence per se, so that the violation, if it proximately caused the plaintiff's injury, is sufficient to prove. And there's no need to prove negligence. There is only a need to prove proximate cause and damages. Negligence per se arises when the injury resulted from the kind of occurrence the statute was designed to prevent, such as driving 100 miles an hour in a 25-mile-an-hour zone, or building a structure without sufficient earthquake supports that falls during an earthquake, and where the plaintiff was one of the class of persons the statute was intended to protect. So that if there is a statute that requires everyone in the state of California to operate their vehicles within the vehicle code, then any violation of that vehicle code can be a negligence per se. Or if there is a statute that requires that every building is retrofitted to protect against damages due to earthquake, and the defendant fails to retrofit his property and during an earthquake it collapses and kills his tenant, that could be a negligence per se. These are seldom used, but it is an instance that is necessary to be aware of when you're dealing with insurance claims. The failure to exercise the care toward others, which a reasonable or prudent person would do in the circumstances, is negligence. And negligence is always accidental, even including driving a tractor through a bridge can be an accident that is a negligence-causing event. If the injury is caused by something owned or controlled by the supposedly negligent party, while how the accident actually occurred is not known, such as a ton of bricks falls from a construction job site and falls onto the body of a pedestrian, negligence can be found based on the doctrine of res ipsa loquitur. Latin for the thing speaks for itself. Bricks do not fall from the sky normally. Bricks do not fall from the sky without some person's act, either negligent or intentional. And therefore, the doctrine makes proof of negligence easier. There are defenses, however. Say an intervening cause exists then there is no liability for injuries caused by the court. The court and jury will apply the but-for test, and if, although you negligently drove your automobile, if another person negligently drove a 16-wheeler in your way and caused injury to you and to other people, the fact that you were acting negligently at the time of the accident will be excused because of the intervening cause of the operator of the 16-wheeler. The court is obligated to do things that are fair and to make certain that only the person responsible is obligated to the third person who is injured, so that it is convinced, whether the judge or jury, that but for the action or interaction of this intervening third person, the operator of the 16-wheeler, the plaintiff would not have been injured, because just driving negligently that causes no damage to a third party is not recoverable. You need all of the elements of the tort of negligence. The intervening cause could be simple. For instance, a postman trips and falls over a rake left in your walk on his way to your mailbox. Could be a cause of action for negligence. But if, in fact, you didn't leave the rake there, your gardener did, to determine if there's a tort liability, the claims investigation must determine if it was the individual homeowner and insured who left the rake, or if it was the gardener who negligently left a dangerous instrumentality for the mailman to trip over. So if but for your action he would not have been injured, then there's no proximate cause, the causation element cannot be determined, and the damages were not as a result of your breach of the duty of care. The actions of the gardener can be asserted as an intervening cause, and that becomes a defense to the liability of the property owner. Comparative negligence means a failure to do an act that a reasonably careful person would do, or the doing of an act that a reasonably careful person would not do under the same circumstances to protect himself from bodily injury. Riding your bicycle into an automobile is not a thing one would expect of a careful person, nor would the driving of an automobile into the path of a bicyclist be a reasonable, careful conduct of an operator of an automobile. So both of them would be found to have been negligent in part, and the doctrine of comparative negligence finds that the plaintiff, by contributing in part to his injury by his own negligence, has a responsibility for at least a percentage of his injuries, and therefore he can only collect that percentage that he is not responsible for. Now, the defendant can't just say, hey, I want to have part of this claim the responsibility of the plaintiff. He can't just say there is comparative negligence as a matter of law if, under the circumstances, the plaintiff did all he was legally required to do and had no duty to do more. While if he's a gorilla, he's got no duty at all, because he can't conceive or deal with the obligation of living in a human society. There is no comparative negligence available where the defendant was driving toward the plaintiff in the wrong lane. The plaintiff who slowed and pulled over was not required to drive his vehicle into the ditch, and comparative negligence was properly withdrawn from a jury's consideration, since there was nothing that the plaintiff could have done to avoid the injury, because it was caused by a defendant who's driving on the wrong side of the road. It just doesn't compute. Now, there's another kind of tort called strict liability. Strict liability, or strict product liability, is a legal rule that says that a seller, distributor, or manufacturer of a defective product is liable to a person injured by that product, regardless of whether the defendant did anything possible to make sure the defect never happened. The defect itself establishes the breach of duty, even if the seller or manufacturer did everything possible to make the product safe. To establish a cause of action for strict liability in tort, therefore, the plaintiff need only prove that there is a product, a manufactured thing, a widget, a motorcycle, an automobile, a blender, a pencil, a fountain pen, that there is a defect in the product, and that damage has been done to the property or person of a third person, the plaintiff, because of the defect, and the defect in the product was the proximate or legal cause of the damage. So that when the brakes on the motorcycle locked up without any reason and tossed the poor driver on his head, that's sufficient to prove a product liability cause of action. A defendant who performs an abnormally dangerous or ultra-hazardous activity can be subject to liability from damages resulting from that activity, regardless of how careful he was. So that if an individual company maintains gasoline storage tanks and allows for them to be exposed to flames or electrical shorts, that can be a subject of abnormally dangerous or hazardous activity. On the other hand, or for another example, if a homeowner decides to reload bullets in his garage and has a 50-gallon drum of gunpowder that explodes, that ultra-hazardous activity, not usual to a home, may be an ultra-hazardous activity that would allow for strict liability in tort. Or if your next-door neighbor decides to make methamphetamines in his back bedroom, and as a result sets a major fire and explosion causing damage to your property, he will be strictly held liable for that ultra-hazardous liability and conduct, even if the defendant exercised the utmost care to prevent the harm. A defendant will be subject to liability for damages resulting from that activity. The doctrine for imposing strict liability has existed since Rylands versus Fletcher was decided in England in 1868. And although most individuals you come across will not have atomic devices available, a major explosion by just having a lot of dynamite can cause the same mushroom cloud when it explodes, and it will cause serious damage. Strict product liability is a manufacturer or seller's tort liability for any damages or injuries suffered by a buyer, a user, or even a bystander as a result of a defective product when that defective product's defect proximately causes injury to property or person. The rule applies even if the seller exercised all possible care in the preparation and sale of the product, and even if the manufacturer exercised all possible care in the preparation and manufacture of the product. The user or consumer has not bought the product from or entered into any contractual relation with the seller. He is still entitled to strict liability in tort. Even if the defendant has exercised the utmost care, liability for an abnormally dangerous or ultra-hazardous activity is considered strict because the defendant's negligence or lack thereof is irrelevant. Even intentional torts are subject to various defenses. For example, if the defendant honestly and reasonably believed in the truth of the charge, the element requiring a favorable termination of the original case fails because he cannot prove the intent of the person who maliciously prosecuted the plaintiff. The defense must be independently proved. It cannot be inferred from proof of malice. It must show clear evidence as to why the person bringing forth a malicious prosecution did so without an intent to harm. One of the ways of proving this defense is by asserting advice of competent counsel, because the advice establishes the probable cause and establishes that the person who created the prosecution was not doing so in a malicious fashion. Thank you for listening. This program was brought to you by Barry Zalma Esquire and Claims School Incorporated. You can contact me by telephone or by email or through my website.